Hey everyone, welcome back to the channel. In today's video, we're covering two separate sovereign citizen cases spread across three different courtroom hearings. Our first case follows Eric Whitford, a defendant who believes that because he's represented himself during previous jury trials, he's fully prepared to handle this case without legal counsel as well. One thing we've seen repeatedly over the years is that courtroom experience doesn't necessarily equal legal knowledge. Many self-represented defendants become extremely confident in arguments that courts have consistently rejected, and that confidence often leads them to overlook the procedural rules that actually matter. After that, we'll move to another defendant whose previous jury trial took an unexpected turn after he refused to properly acknowledge the proceedings, resulting in an arrest warrant and a completely rescheduled trial. The big question is whether he's learned anything from that experience. Let's jump into the first hearing.
I did speak with Mr. Whitford, who's here again this morning or this afternoon. I did speak to him before docket this afternoon. I think we're kind of in a position where I would imagine it's going to be set for trial. So I don't know if you want to call him. I did ask him if he wanted to retain counsel. He indicated he doesn't need counsel. So
okay, I think it's no insurance and some traffic things. Is that right?
Yes, Your Honor. The question was when we were back in court. Do you want me to wait? Are we on?
Yeah, let me go ahead and call it. We're on the record on People's State Call versus Eric Whitford. Mr. Whitford, you go to the lectern there. 25 T588. Appearance is starting with the prosecution.
Darren Bedkowski for the people.
All right, and Mr. Whitford appears without an attorney. Go ahead with respect to your understanding of the status of the case, Mr. Bedkowski.
One of the major points of contention is what happened to Mr. Whitford's vehicle. There was some confusion by the court as to why his car would have been towed. I did reach out to the police department on that. What I've received back, Your Honor, was essentially an abandoned vehicle cover sheet. They said it was treated as an abandoned vehicle. Reasons for tow. The best they have in there is just a check mark on the impound lot.
Okay.
But from my understanding and reading this, it's pursuant to CRS 42-4-1801-1804, notice of towing from a public place.
Okay. Mr. Whitford, all of that has nothing to do with the charge against you in this case. And none of that's admissible at trial. But if you want to plead not guilty, the failure to have insurance, then we can set it for trial.
Actually, I have some procedural questions real quick.
All right.
Is this court subject to the Colorado Rules of Civil Procedure?
No, because this is a criminal court. The rules of civil procedure apply to civil cases.
Am I not being charged with civil offenses?
No, you're being charged with criminal offenses.
Oh, so all three of these are...
The insurance is a criminal offense. The other two are, you're correct, are by statute and by rule considered civil issues.
Then wouldn't
the rules of civil procedure don't apply to them.
It doesn't apply to them?
No.
Okay, so is this court subject to the rules of the Constitution and the Bill of Rights?
Yes.
Is this a common law court or a admiralty?
One of the first arguments raised here is another reference to admiralty jurisdiction, which is something we hear surprisingly often in sovereign citizen cases. That a simple way to think about it is this. If the case involves an ordinary motor vehicle on a public roadway, state criminal law generally applies, not maritime law. Admiralty courts deal with a very specific area of law involving navigable waters and maritime commerce, not routine criminal prosecutions involving automobiles. That's why arguments based on admiralty jurisdiction almost never gain any traction in hearings like this. The court's authority comes from state law and the criminal charges before it, not from symbolic interpretations of legal terminology.
We have nothing to do with maritime issues. Do you want to enter a not guilty plea and set the case for trial, or do you want to see if you can resolve the case by plea agreement with the DA? Those are the only two things I need to find out from you.
I haven't been offered any type of plea agreement yet.
Your Honor, we would be happy just to have him plead to the no proof of insurance and be done with it.
All right. You want to print out a proposed plea, and then Mr. Whitford, I'm going to have you look at that. It'll set forth what the fine for that is. If you decide you don't want to accept that plea, we can enter a not guilty plea on your behalf and set the case for trial. And
I'd rather just enter the not guilty plea.
All right. We'll get the case set for trial. Speedy trial deadline will be 6 months from today. Give me a second. We'll get you a trial date. It's going to be in it'll be in April, given the number of cases we have set. Do you intend to hire an attorney?
No, I'm not a meddling volunteer or a ward of the court.
Right. You're going to try and do the jury trial on your own?
Absolutely.
Okay. Let's try April 29th. This should be a case that we can finish in one day. So April 29th at 8:30 will be the jury trial date. The pretrial readiness conference for that will be on Friday, April the 17th at 10:30. That pretrial readiness conference, Mr. Whitford, we set more than one case for trial every week just because of the number of cases we set for trial. The pretrial readiness conference is to determine whether your case or another one is going to go to trial. What determines that is the case that is closest to its speedy trial date being up goes. I'm fine with you appearing virtually in that April 10th date. I'm not going to set a motions hearing date. I do want to set, it wouldn't hurt for you to observe a trial. Cases are live streamed, and there's live stream instructions on the website if you want to just go on the live stream and watch us do a jury trial so you can see how a jury is selected and how a trial proceeds. You're certainly welcome to do that.
I've been through several trials, won a few of them by myself so far.
Okay, you're not the first person who's told me that. The last person that told me that broke down in tears when we started the trial, but I'm not saying that'll be you, but you're not the first person I've heard that from. You've done a jury trial before?
Yes, I have.
Okay, all right, fair enough. If you have a seat, I'll have my staff get you notice with the dates on it so you don't have to try and remember.
I do have one other question. The entity known as the People of the State of Colorado, is that a creation of the state?
I would say it's a creation by the legislature. So yes, I guess you could call it a creation of the state.
Okay, thank you.
All right.
That brings the first hearing to a close. But this case is far from finished. Several additional hearings are already scheduled. So we'll likely have more opportunities to see how the strategy develops as the case moves toward trial. Now we turn our attention to Anthony Meyer. Before today's hearing, he was already scheduled for a jury trial. Instead of participating in the proceedings, he relied on familiar sovereign citizen arguments, claiming he wasn't the legal entity named in the case and that he was appearing only by special appearance. The judge treated it as a failure to properly appear, issued a warrant for his arrest, and rescheduled the trial. Now we'll see whether that experience encouraged him to change his approach, or whether he'll continue making the same arguments.
Meyer. Please come up to the podium so you can be on a microphone. Otherwise, your statements won't be recognized.
I'm Anthony Meyer. And appear by special appearance to challenge jurisdiction.
Wait until you're at a microphone, sir, so you're being recorded, please.
Okay, very well.
There at the podium.
Approach special appearance only, not as the named entity.
Come on up to the microphone, please. Let me ask, are you Anthony Meyer? Yes or no?
I am Anthony Meyer and appear by special appearance to challenge jurisdiction and confirm administrative default to avoid joinder. And I am approaching under special appearance and not as the named entity.
This is the case of the People versus Anthony Meyer. Are you Anthony Meyer? Yes or no? And that will determine whether or not there's a failure to appear today.
I am, Your Honor, I stated that I am Anthony Meyer.
Okay.
Here by special appearance.
Mr. Meyer, you've already made your statement. You've made your statement.
Interrupting me, please.
You've already made your statement this morning. Now,
Anthony
we need to
Meyer,
reset the case for trial.
Special.
You've already said that. Right?
I'm only here to settle the accounting.
So you have two options. You can go to trial, or you can plead guilty or no contest to the charge of no insurance. You want to have the case reset for trial? Yes or no?
I'm here in honor to settle the matter.
Then let's settle it. If you want to know proof of insurance, you can take that. If you want to go to trial, you can do that.
Can you have the DA read the charges into the record?
You're charged with no proof of insurance. You can plead guilty, no contest, or proceed to trial again?
I don't see any proof of the charging instrument and
You
or
were
any of
issued
the
a summons and
certified
complaint
accounting.
that's adequate to inform you of the charges. You test or stand by the not guilty plea that was entered by the court on your behalf, and we will reset the case for trial. How would you like to proceed?
Before this court can proceed, the plaintiff must rebut the administrative judgment and provide a verified claim by the party with firsthand knowledge.
That's inaccurate. We're going to set it for trial again.
Jurisdiction remains unanswered, and there is an unrebutted administrative judgment on the record, and I request for dismissal.
A motion to dismiss denied. Let's set it for jury trial on, we got speedy trial restarting as of today's date.
Your Honor, for the record, I do not see the officer present in the courtroom, and without a sworn complaining witness with firsthand knowledge, I move the matter to be dismissed.
Motion to dismiss is denied. The officer does not have to be here today. We're going to set it for jury trial on May 7th
I have
at 8:30.
I've yet to see an offer from the DA. Can Mr. Epson please read the charges into the record?
The offer is no proof of insurance.
Okay,
Plead guilty.
can I see those charging instruments and the certified accounting for that?
We're done.
I do not see the certified accounting for the charges or the charging instruments, and I again request dismissal. I'm hereby special appearance to confirm the administrative default. I've given you guys the motion, or sorry, the notice. I've given you guys the notice, order, and the motion to dismiss, and I've also put into the record an acceptance of offer. And again, Anthony Meyer, the living man, accepts the presentment of the offer for the case number 23T0294 to set off, settle, discharge, and close all accounts, including but not limited to the equitable subrogation IRS 941, the 941V, the 1099A, C, and OID, or supplied supersedes bond. I, Anthony Meyer, the living man, does not consent to go to prison on behalf of the named defendant, estate Anthony.
As it turns out, very little has changed. Rather than focusing on the legal issues the court is trying to resolve, the defendant returns to many of the same jurisdictional claims that caused problems during his previous appearance. The judge, however, makes it clear from the beginning that the hearing is going to remain focused on the applicable law and established courtroom procedures, not arguments that have already been addressed countless times.
Motions are non-persuasive and essentially gibberish. Motions to dismiss are denied. The case is being reset for jury trial. You've seen what happens if you pull this at a jury trial. It will register as a failure to appear. A new warrant will issue, and we'll keep going through this
I'm here in
until
honor.
you show up and acknowledge in front of a jury that you are Anthony Meyer. So again, you can go back to trial. We've set a trial date, or you can plead guilty or no contest. Last chance. Want to set it for trial? Yes or no?
Again, I'm here by special appearance to challenge
We're
the
going to
jurisdiction.
trial May
and to confirm
7th
the
at
administrative
8:30.
default.
We're going to do a status pretrial conference with a mandatory appearance.
I'm here in honor. And the DA has yet to present me anything, no offer, has showed no proof. Officer is nowhere to be seen. I'm present right here in front of you. You're saying that I'm not here. I'm
Judge, for the
telling you that I'm
record-
here
For the
especially.
record, the officer was here
No,
on
he wasn't.
Thursday. Both officers came in one came in from Florissant, one came in from Park County.
The officer
Maybe
does not,
these
Mr.
officers,
Meyer, the officer
but
does not
Brock-
have to be here today.
He's
You
never
are-
been here for
He was-
not the arraignment, not for the hearing, nor was he here for the jury. And then you
Had-
said that I wasn't here last time when I was present right here in front of you,
I called
telling
for
you.
Anthony Meyer twice. You refused to have a seat, so I found you failing to appear to be tried.
And I was telling you that I'm here
Had
by
you taken
special
your
appearance.
seat, had we sworn a jury and had the officer not appeared, it would have gotten dismissed. That didn't happen because you failed to take your seat at the defendant's table. So
I was willing to take my seat,
No,
Your
you
Honor. I
were
just
not.
wanted to let you know that I was here by special appearance to settle the matter.
Okay.
And again, today I'm here only to settle the matter.
the only way to settle it is to plead guilty or no contest.
Are you practicing law from the bench?
No.
No, I'm
Okay,
making the
we're
offer.
done.
Answer to plea on my behalf the first time.
As the statute authorizes, if someone refuses to plea, the court can enter a not guilty plea. So head down the hall, they'll get your paperwork. We'll see you here in person, March 4th at 3 o'clock for pretrial conference. And the case is set for jury trial May 7th at 8:30.
You guys have my offer, and so I'm waiting for the certified accounting and for the instrument for this to be able to proceed forward. So
Don't hold your breath. Go down the hall to the
We'll be
clerk's
the same.
window. Thank you.
Thank you, Your Honor.
The judge handles the situation with patience while making it clear that repeating the same unsupported legal theories isn't going to change the outcome. Point one of the unfortunate realities here is that the defendant believed there were legitimate procedural issues with the prosecution's case. There were proper legal avenues available to raise those concerns. Instead, by focusing almost entirely on arguments about legal entities and jurisdiction, he created additional complications for himself, including the arrest warrant that brought him back before the court. Sometimes the strongest legal strategy is simply addressing the actual issues before the judge rather than rely on arguments that have consistently failed in courtrooms across the country.
Mr. Anthony Meyer. Case number 2023 T294, appearance on bond. Case is currently set for jury trial. Take two on May 7th at 8:30. Good morning, Mr. Meyer.
Good morning, Your Honor.
Any questions to begin with?
I, Anthony Meyer, am appearing specially, not generally, on behalf of the named defendant estate, also known as Anthony Janae Meyer, here to challenge jurisdiction and to confirm the administrative default and to avoid joinder. And only here to settle the accounting.
So to summarize your options again, of course, you're presumed innocent. We have you set for a jury trial. Other options to enlist the services of an attorney or plead guilty or no contest to the charge. Mr. Ibsen, is there a stipulated plea offer regarding any potential jail time?
Judge, I was going to make the defendant a plea offer actually, I was going to offer a deferred judgment to no proof of insurance for a year with 60 days jail suspended on condition that he provide proof of insurance to the court every month. Court of probation.
So there's a plea offer that includes a deferred judgment with required ongoing proof of insurance, or you can plead guilty or no contest with a fine and court costs, 4-point assessment against your driving privileges, or of course, carry on with the jury trial scheduled in May. Mr. Meyer, of those options, do you want to continue with the trial setting?
I would say at this time, I have put in the notice motion in order, and before the court could proceed, the plaintiff must rebut the administrative judgment and provide a verified claim by the party with the firsthand knowledge. And would like to see if I could have a written response to my offer and 72 hours to review with my attorney.
You do have the right to discovery. Have you requested that from the DA's office?
I have not.
So you can make a request for discovery. That'll give you the police reports and other discoverable information in the file, any body cam video of the incident, anything that the state has to provide to you under Rule 16. Then you can assess that evidence and decide how best to defend yourself at trial if you want to continue with the trial. You do have the right to confront any of the state's witnesses. That right means that at trial, those witnesses would be called, put under oath, and you could cross-examine them. You do have the right to present your own evidence, though you don't have to. It's the state's burden to prove the charge beyond a reasonable doubt. You don't have to take the stand or call witnesses, but you, of course, have the right to if you choose to. Other than that, the court has denied your motions to dismiss. The complaint filed in the case is adequate under Colorado law to advise you of the nature of the charge, date, place, and time. So we are going to proceed to trial unless you choose to take a different path. Any additional questions today?
I would just say that I still don't understand the charges. I haven't seen the charging instruments and or certified accounting. And at this time, jurisdiction remains unanswered. And there's an unrebutted affidavit or administrative default judgment on the record. And again, I just request dismissal.
Not surprisingly, the motion is denied. From the court's perspective, the defendant had an earlier opportunity to participate in the scheduled jury trial. Instead of addressing the case on its merits, he chose a strategy that resulted in the proceedings being delayed and ultimately reset. Once it happened, the court simply continued moving the case forward to the normal legal process. Choices made during earlier hearings often have lasting consequences. And this case is another reminder that procedural decisions can significantly affect how a case unfolds.
The motion to dismiss is denied. The complaint that you were issued by the officer is adequate to inform you of the charge. That's a charge of operating a vehicle without showing proof of insurance. It indicates the date, place, and time, that being within Park County, thus conferring jurisdiction on this court. So the next court date.
Shows there was a pre-trial for tomorrow. I'm not sure if that could be pushed out or could also be pushed to Zoom. I actually don't reside in this state. I'm kind of here because I have to be. And so, yeah, either if I could do a Zoom for tomorrow and or it could be pushed out a little bit. I guess there's a few additional things I could request and or file.
Okay. So you're currently on bond. The court, Mr. Ibsen, any objection to modifying bond to allow Mr. Meyer to leave the state
No, sir.
pending the trial?
No.
Okay, so the bond is not forfeit. It continues. That's a $1,000 cash bond posted last time. We'll continue the bond until the case is resolved. Modify the bond to allow you to leave the state. Are you residing in Arizona?
Florida.
Florida now, okay. The next court date that the court is showing is the jury trial. Well, we've got a pretrial readiness tomorrow. Okay, that's what you're referring to. I propose we vacate that.
Okay.
And we just leave it on for trial May 7th at 8:30. You would have to be here in person for that.
Oh, yeah. And could I add one more thing?
Sure.
I would like to motion and order this court to revoke and revest the court's case trust securities. And I am motioning and ordering the court and the state to produce the IRS 1099-A QSIP, bid bond, performance bond, and payment bonds for set-off, settlement, adjudication, adjudicate all claims, balance all the accounts to zero, discharge and close all accounts, and return remain funds to me and dismiss the case with prejudice. Unless I can get the certified accounting, just because this would be a concealment of my tax records.
I have no idea what you're asking. So the motion's denied as inapplicable, incomprehensible, and unpersuasive entirely. So the case remains set for jury trial May 7th at 8:30. Next time, if you're not here, a warrant issues. If you're here and refuse to acknowledge your presence, but I know you're here, the issue would be either to issue a warrant, take you into custody, or proceed with you in absentia, noting that you're present but refusing to participate. So you can show up and participate. You can show up and refuse to participate. In other words, not have a seat at the defense table and acknowledge that you're the individual named Anthony Meyer. And then at that time, I'll decide whether to put on the trial anyway or take you into custody again and go through the whole bonding out and keep this cycle going.
I have the right.
Or you can refuse to come and we'd issue a warrant.
I have the right to appear specially and not generally, though, correct?
No, you have to appear as Mr. Anthony Meyer. If you do not, but I know you're sitting in the audience, I may decide to put on a trial with you in absentia that you're refusing to participate but are present, or I'll issue a warrant and have you taken into custody. Those would be the options if you're not willing to have a seat at the defense table acknowledging that you are Mr. Anthony Meyer. Okay?
Okay.
Any other questions today?
Judge, just for the record, and I want to make sure the record's clear on this. Ms. Lindsay checked our records. We have given Mr. Meyer discovery in this case.
Okay. Thank you, sir.
Okay.
So that'll do it for today. Head down the hall if you want a printout of your next court date. Of course, that is the jury trial. You need to be here at 8:30, May 7th, acknowledging that you are Mr. Anthony Meyer, the accused. If you refuse to do so, I've explained what the court's options are, limited to a warrant or proceeding against you in absentia, noting that you are present but refusing to participate. So we'll see you in May, sir.
Awesome.
Thank you.
Thank you very much, Your Honor.
We'll take a recess until 11 o'clock.
And that brings us to the end of today's video. Both of these defendants still have upcoming court appearances, so there will almost certainly be additional developments to cover in the near future. It'll be interesting to see whether either of them adjust their legal strategy as their cases move closer to trial. If you enjoyed today's courtroom breakdown, don't forget to leave a like. If you have thoughts about either of today's cases, I'd love to hear them in the comments below. And if you're new to the channel, be sure to subscribe and turn on notifications so you never miss future courtroom coverage, legal commentary, and case updates. Thanks for watching, and I'll see you in the next video.